Welcome to our video presentation describing the draft bylaw prepared by Mississauga to address the situation commonly referred to as renovictions. My name is Dominic Tadino. I'm the Deputy Director for Special Projects with the Legal Services Division of the City. I will be joined by my colleagues throughout this video presentation, and they will be introducing themselves during the video presentation. Feel free to forward the web link to this video to others in your community who might also be interested in learning more about our bylaw. Slide. By way of background, on November 13th, 2024, a resolution of the Mississauga General Committee was passed directing city staff to conduct research and prepare a renoviction bylaw modeled on the City of Hamilton Renovation License and Relocation Bylaw and the City of Toronto Renovictions Bylaw. From March to May 2025, the city completed its first round of public engagement with external stakeholders. This included an online survey, a virtual community meeting held on April 9th, 2025, and two facilitated in-person sessions with external stakeholders representing both tenant and landlord groups. The information garnered from this first round of public engagement was used to draft the current version of the bylaw. This past September, City Council members asked staff to share the draft bylaw with the general public and to solicit further feedback from stakeholder groups. Please take some time to read the draft bylaw. Slide. Turning now to the Mississauga's bylaw, it's intended to apply to all residential rental units within the City of Mississauga in the same way the Hamilton and Toronto bylaws do. In addition, this bylaw will not apply to any rental units that are exempted under the provisions of the Residential Tenancies Act. If you live in a rental unit not covered by the Residential Tenancies Act, this bylaw will not apply to your unit. Once this bylaw is passed by City Council, any landlord that delivers an N13 notice to a tenant will be required to obtain a license from the City of Mississauga before commencing any renovation or repair work to the rental unit. An application for the license must be submitted to the city within 7 days after delivering the N13 notice to the tenant. Landlords are required to obtain a separate license for each rental unit being repaired or renovated. Slide. All license application forms must be submitted to the city's license manager, who works with the city's municipal bylaw enforcement team. The application form must be accompanied by further documentation, some of which include the following: a copy of the N13 notice delivered to the tenant, a copy of the building permit issued by the chief building official to the landlord, a copy of the signed tenancy agreement for the tenant's rental unit, payment of the applicable license fee, a signed copy of the qualified person report confirming that the proposed repairs or renovations are so extensive that they require the landlord to have vacant possession of the tenant's rental unit. A qualified person means a person licensed by the Ontario Association of Architects or the Professional Engineers of Ontario, or such other professional as may be deemed qualified by the license manager from time to time. The license manager will issue a license to the landlord only after the application package is complete and in full compliance with the bylaw. Slide. The license term and the cost will depend on which option suits the landlord best. Landlords will have the option of applying for a license with a 3-month term, a 6-month term, or a 12-month term. The cost of a 3-month license will be $150. The cost of a 6-month license will be $300. Finally, the cost of a 12-month license will be $600. This 3-tier license structure was created in part to decrease the financial costs on small landlords operating with limited budgets. We would note that Hamilton and Toronto bylaws only provide for a more expensive 12-month license term. If during the construction work, the landlord discovers that the repairs or renovations cannot be completed within the term of the original license, landlords will have the right to apply for a renewal license at least 15 days prior to the end of the license term. The cost of the renewal license will be the same cost as the original license. For example, if the landlord is asking for a 3-month renewal license, the cost will only be $150. The landlord will also have the right to transfer or assign the license. In other words, if a landlord decides to sell the property containing the rental unit during the term of an existing license, the landlord may transfer or assign the license to the new owner after obtaining the written consent of the license manager. Slide.
Thank you, Dominic. My name is Anna Featherston-Reichich, and I'm an articling student with the City of Mississauga in the Legal Services Division. So in addition to the licensing process that Dominic just described, the city has included tenant protections in the draft Renovictions bylaw to ensure that there's oversight throughout repairs or renovations and to support tenants who have been displaced. Slide. While consulting with tenants, the city heard that they can feel vulnerable during a renoviction because they don't understand the process or what their legal rights are. Landlords often take advantage of these circumstances to force a tenant to leave their rental unit permanently without offering them the right to return. For example, we heard that landlords have told tenants that if they want to return to their unit after renovations are complete, they have to pay significantly higher rent than they previously were, despite this contravening the Residential Tenancies Act. To ensure that tenants are adequately informed of their legal rights throughout a renoviction, the city will require landlords to post a notice on the tenant's door and provide the tenant with an information package within 8 days of submitting their license application. The notice on the tenant's door will ensure that the tenant is aware that the landlord has submitted an N13 application to the Landlord and Tenant Board and that the renovictions process has begun. The information package will provide the tenant with more detailed information on how the renovictions process must legally proceed under the Residential Tenancies Act and outline general LTB processes. To ensure that a landlord has completed all of these steps, the city's proposed bylaw will also require landlords to submit a mutual certification form signed by both the landlord and the tenant within 18 days of submitting a license application. Slide. Another tenant protection that the city has implemented into the Renovictions bylaw is a moving contribution payable by the landlord to the tenant. A landlord would have to make this payment regardless of whether the tenant chooses to return to the unit. The city heard from tenants that when they are displaced during a renoviction, the cost of moving out of the unit while they either await for repairs to be completed or seek to permanently relocate can be unduly burdensome. Therefore, the city decided to add a provision to the bylaw requiring landlords to support the tenants during this move by contributing to their moving expenses. To determine what the fixed moving expense should be, the city contacted moving companies across Mississauga to assess on average how much it costs tenants to move. The city found that moving companies typically charge different rates based on the size of the unit that the tenants are moving out of. Units that are greater than 1 bedroom are more expensive to move than units that are 1 bedroom or smaller. Based on these calculations, the city developed a fixed price that landlords would have to contribute to a tenant's moving expenses based on the size of the unit that the tenant is moving out of. These fixed prices seek to alleviate some of the financial burden of moving for tenants while ensuring that there's a limit to how much a landlord will have to pay. Under the city's proposed bylaw, if the tenant is living in a unit that is 750 square feet or less, the landlord would have to contribute $1,000 to the tenant's moving expenses. If the tenant is living in a unit that is 750 square feet or more, the landlord would have to contribute $1,500 to the tenant's moving expenses. To verify that the landlords have paid this moving contribution, landlords will have to submit a declaration form within 18 days of submitting their license application, confirming that they paid the tenants for their moving contributions. Slide.
Hello, my name is Katie Paff, legal counsel in planning and development law with the city. Coupled with the moving contribution, as described by Anna, the top-up payment is another tenant support tool that the bylaw proposes. Before describing how the top-up payment works in Mississauga's proposed bylaw, it is important to understand the framework for tenant support in cases of renovations found within the Residential Tenancies Act. I will refer to it as the RTA. As of today, the RTA provides a scheme for tenant compensation in cases of extensive renovations that require a unit to be vacant, and it is found at Section 54 of the RTA. Underneath this scheme, compensation is determined based on whether the tenant has elected to return to the unit post-renovation. This is called the right of first refusal. As you see on the screen, where the tenant is not returning to the unit, the landlord can either offer another rental unit that is suitable to the tenant or offer financial compensation. Regardless of whether a tenant has elected to return or not, financial compensation under the RTA breaks down into two scenarios depending upon how many rental units are in the landlord's complex, less than 5 or more than 5. It is 1 month's rent where the landlord has less than 5 units in the complex, and 3 months' rent where the landlord has more than 5 units. Referring now to where a tenant has confirmed in writing their right to return to the unit, the landlord must provide them the earlier of either 1 month or 3 months' rent, depending upon the number of rental units, or the date of reoccupancy post-renovation. The city heard feedback during its consultation and engagement sessions that when renovations are underway, it is possible that renovations last longer than the period provided for under the RTA. In the case of tenants waiting to reoccupy the unit post-reno, many tenants are displaced to market rate rental units where their rent per month is much greater than the rent paid at the unit undergoing the renovation. Change the slide, please. To address this, the city has proposed a rent top-up payment in its bylaw. The rent top-up payment is only engaged where a tenant has confirmed in writing that they will be returning to the unit post-renovation. The period during which the landlord is obliged to pay the top-up payment to the tenant begins at the time the RTA compensation period expires, and this obligation then terminates when the unit is ready for occupancy. The payment is calculated as the difference between the prior rental rate the tenant was paying and market rent, as provided through data from the Canada Mortgage and Housing Corporation. Full details of the top-up payment scheme are found at Section 16 of the city's proposed bylaw. Change the slide, please. For tenants that have elected to not return to the unit post-renovations, the city has created a list of factors a landlord should consider when offering an alternate unit that is suitable to the displaced tenant. These factors were informed by feedback received through the consultation and engagement sessions. Some of the key considerations are highlighted on the screen, and full details are found in the draft bylaw at Section 15. Change the slide, please.
Hello, my name is Ryan Regent, and I'm the manager of the city's Specialized Housing Enforcement Unit. Next slide, please. The Specialized Housing Enforcement Unit is responsible for overseeing several rental housing related programs, including the city's rental standards program, which regulates apartment buildings. the city's short-term rental accommodation licensing program, which licensing rentals for periods of 30 consecutive days or less, and then the lodging house program, which licenses multi-tenanted properties. The Specialized Housing Enforcement Unit is also responsible for the development of new regulatory frameworks and will be responsible for administering and enforcing the proposed Renovictions bylaw if approved. Today, I will be touching on the role of the license manager and the inspection components of the proposed Renovictions bylaw. As some viewers may not be familiar with the role of bylaw enforcement in the community, I will begin by providing an overview of how the city's enforcement division operates to protect residents and ensure safe, well-maintained communities. Next slide, please. The city's enforcement division includes roughly 300 dedicated staff who work across a wide variety of specialized service areas, including property standards, investigations and enforcement, bylaw compliance and enforcement, licensing, permits and regulatory services, animal services, parking enforcement, security services, strategic program policy and delivery, as well as specialized housing enforcement. Together, our staff are responsible for administering and enforcing over 30 municipal bylaws related to licensing, permits, and then other regulatory services. A few viewers may be familiar with bylaws such as property standards, adequate temperature, zoning, business licensing, noise control, nuisance gathering, parks, short-term rentals, and rental apartment buildings, to name a few. The Enforcement Division's mandate is to protect the public by ensuring safe, secure, and well-maintained communities where people can live, work, and visit. If you'd like to learn more, you can visit the link that's displayed on the screen or call 311. Next slide, please. Building off what Dominic had touched on early, the proposed Renovictions bylaw, in the proposed Renovictions bylaw, the licensing manager plays a critical role in ensuring that landlords meet all the required conditions before and during the renoviction process. As indicated, landlords will be required to submit an application to the license manager within 7 days of issuing an N13 notice. Staff will review each application to ensure they are complete and contain accurate information. Under the proposed bylaw, the license manager will retain the authority to refuse, suspend, or revoke a license in the following circumstances. If an application contains false or misleading information, if the landlord has violated any municipal, provincial, or federal laws, if fees have not been paid, or if the building permit issued for the renovation has been revoked by the chief building official. If a license is refused or revoked, the landlord will be provided with an opportunity to correct any deficiencies or provide more information before a final decision is made. This process is designed to balance transparency, due process, and accountability, ensuring that only compliant landlords proceed with renovations that displace tenants from their homes. Next slide, please. Under the proposed Renovictions bylaw, city enforcement officers will have the authority to inspect rental properties and related documentation to confirm compliance with licensing requirements. Inspections may involve on-site visits to confirm that the landlord has fulfilled their requirements. For example, to determine that they have posted a tenant notice and delivered the tenant information package in accordance with the bylaw. Officers will also conduct follow-up inspections to confirm that any orders or notices that have been issued have been complied with within the prescribed timeframes. Inspections may also involve a review of records, and officers may request the production of relevant documentation when necessary. If a violation is identified, officers will have the authority to issue a notice to the landlord requiring that they correct the issue by a specified date. This is known as a compliance date. For example, if an officer conducts an inspection and determines that the tenant notice was posted incorrectly, officers may provide written instructions to the landlord outlining the bylaw requirements and specifying what actions are required to achieve compliance. In the event that a notice is issued and the landlord fails to comply, the city will have the authority to complete any required work and recover the costs in the same manner as property taxes. This inspection framework aligns with the existing enforcement practices and ensures consistent, fair, and enforceable oversight to protect both tenants and the integrity of the city's housing stock. Next slide, please. An important component of the proposed bylaw involves tenant communication and fair treatment. Once a repair and renovation license is issued, landlords will be required to provide bi-weekly written updates to tenants about the status of renovations, notify tenants of any delays or changes to the completion date of the repairs or renovations within 5 days of becoming aware of the same, and notify the tenants of any change to their contact information within 5 days of the information being changed. Next slide, please. The proposed bylaw also outlines specific activities that landlords are prohibited from doing. Those include preventing tenants from obtaining legal information or advice to make decisions regarding the tenant's rights under this bylaw, advertising a renovated or repaired rental unit for rent if the tenant of that unit has exercised their right to return to the unit in accordance with the RTA, unless the tenant notifies the landlord in writing that they no longer wish to return to that unit, and making representations that they are licensed under the bylaw when they are not. These requirements are designed to strengthen communication and transparency between landlords and tenants, ensuring tenants can make informed decisions about their housing. They also aim to prevent the misuse of renovations or repairs as a means to displace tenants under the pretext of compliance or improvement. Next slide, please.
Hello, my name is Nupra Kotecha, and I'm a legal counsel with legal services at the city. I will now outline the penalties or fines that landlords may face if they contravene the proposed bylaw. First, the city can impose an administrative penalty. The city is authorized under the Municipal Act 2001 to issue administrative penalties for contraventions of the bylaw. Administrative penalties are monetary penalties that a municipality can impose for a bylaw contravention as an alternative to prosecution under the Provincial Offences Act. These penalties are intended to encourage compliance and are imposed by bylaw enforcement officers. If an administrative penalty is not paid within a specific time frame, the city can add the penalty to the property's tax roll and collect it like property taxes. The bylaw will be designated under the city's licensing administrative penalty bylaw. This means that where a bylaw enforcement officer is satisfied that a contravention has occurred, they can issue an administrative penalty notice instead of initiating a court process. Where an administrative penalty has been imposed on a person, they cannot also be charged under the Provincial Offences Act for the same offence. Another aspect of the administrative penalty system is that it allows a person to request a review or an appeal of the penalty notice to a screening officer employed by the city. If they are still not satisfied, then they can request a further review by a hearing officer that is not employed by the city. Staff propose that the administrative penalty amounts range between $500 and $1,000 under the administrative penalty system. The second type of penalty or fine that can be imposed is that the city can lay charges under the Provincial Offences Act. They can lay a charge pursuant to Part 3 of the Provincial Offences Act. Part 3 charges are for more serious bylaw violations that require a court summons. Where a bylaw enforcement officer determines that a serious bylaw violation has occurred, they can lay a charge by swearing in information before a justice of the peace and then serving an accused with a summons. The city would then prosecute the case in court through its own prosecutors. The bylaw outlines penalty amounts for offences in accordance with the permissions under the Municipal Act 2001. Contraventions of the bylaw may result in charges laid under Part 3 of the Provincial Offences Act as follows. Upon conviction, a person could be liable to a minimum fine of $500 and a maximum fine of up to $100,000. Generally speaking, the City will seek to follow a progressive enforcement approach that prioritizes voluntary compliance through education and communication as the preferred approach before resorting to penalties and fines. Next slide, please. Thank you for viewing our video presentation about the proposed City of Mississauga Renovictions bylaw. As noted, please take the time to review the draft bylaw. We anticipate that it will be presented to the City's General Committee in early 2026. For further information, please visit the project website at mississauga.ca/renoviction. Thank you.